In the United States of America, in our criminal justice system, a lawyer's job is to establish reasonable doubt. A lawyer doesn't need to prove that his or her client could not possibly have committed a given offense. The lawyer needs to establish reasonable doubt. And in the Weinstein case, what makes the testimony of the various women who he victimized, as well as of women and men who were aware of his reputation for victimizing women in that certain way, what makes their testimony relevant is that in cases of people accused of the assaults or abuse, of the assaults or abuse of the nature that Harvey Weinstein committed, very rarely when the suspect is guilty was there not a pattern of behavior. There is usually a pattern of behavior that can establish. It may not necessarily have involved anything specifically illegal, but there was a pattern of behavior involving lascivious comments, inappropriate body language, inappropriate other kinds of things that I won't go into detail about, but there is some sort of a pattern of behavior in almost any case where a suspect is guilty. So when defense attorneys provide tales about 75 women who can say, oh, I worked with this guy and I never felt uncomfortable in any way, and I never heard of him making anyone feel uncomfortable, that obviously does not disprove the victim's, that obviously does not disprove an accuser's story in and of itself, but a defense attorney could use it to sow reasonable doubt in the jury's mind, which is why establishing a pattern of behavior is something that prosecuting attorneys place a big emphasis on. It prevents defense attorneys from derailing the juror's mind in that way. So the basis of that the courts in New York State have used to throw out Harvey Weinstein's conviction, this is just my opinion, I think this sets a very scary precedent that's going to make it harder for women and men who have survived that kind of abuse or assault to receive justice. Again, this is just my opinion.